The Appellate Division, First Department is now in session. Welcome to our virtual oral argument. I will now call the calendar. People versus Korea is 4-1 for the appellant and 4 for the respondent. Nrt New York versus Corcoran Group is 6-1 for the appellant and 6 for the respondent. Milagros versus Koshana is submitted. People versus Freeman is submitted. Sigolofskaya versus New York City Transit Authority is 4-1 for the appellant and 4 for the respondent. People versus Schmielwski is 6-1 for the appellant and 6 for the respondent. Priestley versus Pandemic is 8-2 for the appellant and 8 for the respondent. Zagerson versus New York City Department of Education is 4-1 for the appellant, 4 for the respondent. Mellon versus Mellon is 7-1 for the appellant and 7 for the respondent. Flowers versus 73rd Townhouse is 8-2 for the appellant and 8 for the respondent. Chuli versus Cabgram Developer is 6-1 for the appellant, 6 for the respondent. People versus Ramos is 7-1 for the appellant and 7 for the respondent. On Resolute, has counsel appeared for the appellant?
Yes, Your Honor. This is Melissa Holsinger for the appellant.
Okay, so 8-1 for the appellant, 8 for the respondent. People versus Ugwu is 7-1 for the appellant, 7 for the respondent. Concepcion versus City of New York is submitted. Viju versus New York City Health and Hospitals is submitted. Tavares versus Ronald Holden Corp is submitted. And Savage versus Barron is submitted. Because in 3 of the cases, at least one of the justices have recused themselves, I will be calling those 3 cases at the end of the calendar in the order in which they appear in the calendar. And those 3 cases are Priestley versus Pandemics, Mellon versus Mellon, and Flowers versus 73rd Townhouse. So those will be the last cases called on the calendar. Counsel, please do not speak when a justice is speaking. This is especially important during virtual argument. Please keep your microphones muted unless you are arguing. Thank you in advance for your cooperation. The first case being argued is People versus Korea. Appellant.
Good afternoon, Your Honors. Molly Schindler on behalf of Felix Correa. May it please the court. The SORA court erred in adding 55 extra points to the risk assessment instrument that the board did not recommend and that were not supported by clear and convincing evidence. Mr. Correa's correct RAI score fell in the level 2 range, and we asked this court to modify his level accordingly. Mr. Correa should not have received any points under factors 3 and 5 because the only victim he committed sexual conduct against was an adult.
Counsel, this is Judge Singh. Is that that statement you just made, is that consistent with the law of the state that actual physical contact is necessary?
No, Your Honor, and I do not assert that physical contact is necessary. The Court of Appeals has held that it is not, but they have also not held that the dispositive factor is mere presence, physical presence.
Well, but it's more than mere presence, right? Wasn't the child brought into the room by the defendant?
Yes, he was brought into the room, but there is no.
So it's not a spontaneous event that occurred, but rather a conscious decision by the defendant to bring the child in and then sexually assault the mother in front of the child, correct?
We know that, yes, it was to bring the child in and sexually assault the mother while the child was present. What we don't have is any affirmative evidence that the conduct was intended toward the child. In other words, that he forced the child. What would be the reason?
What would be the reason for the defendant to bring the child in to observe the inappropriate sexual contact?
He may have brought him in, and this is speculation because, of course, it is the prosecution's burden. But this one reason could be that he wanted to provide a hostage while the sexual conduct was taking place. But there is no affirmative evidence that he forced the child to even watch or do anything other than be present. And the SORA guidelines are what states that it has to be sexual conduct against the individual in question for that to constitute.
What about the line of cases from the 3rd Department which seem to say the mere presence is enough? such as People versus Controvert and some of the other cases? Why shouldn't we follow that line of reasoning?
This court has never held that, and neither has the Court of Appeals. And those cases actually predate the Court of Appeals holding in Izzo, which actually rejected the idea that the lack of physical presence was the dispositive factor.
But didn't, in fact, in Izzo, didn't the court actually hold that it was okay where there was a webcam chat and no physical contact, that was sufficient? Doesn't that support the holding in Controvert that it's not required to have some contact?
No, and again, I'm not asserting that physical contact is needed, because it certainly is not under Izzo. What is needed is sexual intent toward the person at issue, and that's what happened in Izzo. There was sexual conduct that was done toward that child, even though it wasn't physical in nature. The defendant was making sexual statements toward the child, and he actually pleaded guilty to endangering the welfare of the child based on the sexual conversations that he had with that child over the webcam. We should
take into account in this case that he had the child come into the room after the mother was already in the room without the child, therefore having the mother have the child be present.
Again, Your Honor, the presence alone is not enough without some affirmative indication, which the prosecution would be required to provide, that the child was being affirmatively forced to watch or involved, or that the conduct was directed toward or against that child, not toward or against the mother. And that's what's lacking.
Let's hear from Respondent, and you'll have a chance for rebuttal.
Thank you.
Go ahead.
Good afternoon. May it please the court, Catherine Reed for Respondent, the Office of the Bronx County District Attorney's Office. Your Honors, this court should find that defendant was properly adjudicated a level 3 sexually violent offender, or in the alternative, that an upward departure was warranted. This was a heinous offense which involved force and aggression against strangers, including children, by a recidivist who is proven to commit crimes even after incarceration. The SOAR court below correctly assessed defendant a level 3 sexually violent offender.
How do you respond to your adversary's comments that there's really no sexual contact or has been shown with respect to the child, even though he was brought into the room?
Well, Your Honor, a couple things. First, Factor 3 does not require, as you have mentioned, any actual physical sexual contact between the offender and the victim. And we would argue that here, defendant did actually force the child to witness this event. Defendant, after he robbed the female victim of her belongings, then pulled the boy, still bound in duct tape, into a separate room to witness this sexual assault. There is simply no non-sexual explanation for bringing the boy into the room at this point, other than to victimize him.
Well, your adversary suggests that maybe it's a hostile situation.
Your Honor, this is clearly, in any event, this is clearly the type of inappropriate sexual behavior here relevant to defendant's risk of reoffending. There's no actual physical sexual contact required. Additionally, I would like to point out the Court of Appeals in People v. Knox, which is cited in defendant's brief on page 17, footnote 5, held that unlawful imprisonment is a SOAR level offense, even when there's no sexual component. So that could also be an argument here that that is essentially what was going on. But in any event, even if this court were to disagree with the assessment of points under all 3 factors, which is what is required for success here, this court should nevertheless affirm the SOAR court's alternative finding that an upward departure was warranted. The risk assessment instrument here did not adequately account for defendant's history of incarceration, including the immediacy of his prior felonies, nor did it account for the repulsiveness of defendant's crime here. Again, the purpose of SOAR here is not just to analyze defendant's risk of reoffense, but also the potential harm that would be inflicted if he did reoffend. And the harm here is immense. This was an armed home invasion, robbery, and sexual assault where a 12-year-old boy was forced to witness his mother be sexually assaulted in front of him. If your honors have no further questions, I rest on my brief and ask this court to affirm.
Thank you very much.
Your Honor, very brief. Thank you, Your Honor. Very briefly, I would ask Your Honor to consider that there are no factors that aggravate this that are not already accounted for by the risk assessment instrument, which did in fact directly account for the recency of his prior felonies. And in any event, those aggravating factors were outweighed by the ample mitigating information This was a very long prison sentence, far longer than his previous ones. He had the opportunity to not only participate in treatment, but to excel as well. He did so well in his substance abuse program based on his previous substance abuse history that his counselor just raved about him to defense counsel.
Even if one was to consider that they're bringing the young boy into the room to witness his mother be sexually assaulted, that he's not a victim under SORA, wouldn't that in and of itself be an aggravating factor?
Your Honor, an aggravating factor does not just need to be unaccounted for by the RAI, but it also needs to increase one's risk of sexual recidivism. And that is not demonstrated by the people here. But in any event, that would too be outweighed by the mitigation under step 3 of the departure analysis, which is the totality of the circumstances. The evidence demonstrates that.
Thank you very much. Thank you very much. The next case is Nrt New York versus Corcoran Group.
Good afternoon. Jason Burke for the appellant. May it please the court. The lower court granted Middlegate summary judgment based on UCC 322 because it had priority in that it perfected its security interest first.
Counselor, this is Judge Friedman. I have a question.
Sure.
So what we're dealing with is not UCC 9-330 subdivision D, and an instrument. What is the instrument here?
It's the notice of assignment that Commission Express purchased.
So if that's what the instrument is, the purpose of filing UCC 1 statements is that the first one to file has priority over those who file subsequently. Here, unquestionably, Middlegate filed earlier in 2015. You have this this assignment, which is, I think, from 2018 or 2019. So if you somehow get priority over Middlegate, how does this whole system of priority work with UCC 1 financing statements?
Well, that's because my client, in order to gain priority as a purchaser of an instrument, had to take the instrument in good faith for value. And the public policy behind that is to...
What about the requirement, which is explicit under 330, that Middlegate had to take possession of the instrument in order to be protected by that provision? And based on the undisputed record in our case, Middlegate never did take possession of the commission, which is the security interest we are referring to in this case, or that was perfected.
That's correct. Middlegate didn't take a possession.
No, I think, counsel, she means your client never took possession. Please.
Sorry, you didn't take possession. I'm sorry, I'm confusing.
So could you answer the question?
All that's necessary is that Commission Express has possession of the instrument. And once it has that and it's satisfied all the elements.
Instrument, the commission itself, which it obviously never took possession of. Because that's what everybody has a security interest in, the commission. The assignment or right to a commission is not the security instrument. The instrument is the commission.
So the UCC defines instrument as negotiable instrument or other writing. And the commission account itself is not a writing. It's not an instrument as defined by UCC.
All you have is the right to an assignment of the commission once it's received. It's never been received yet. How can you have possession of it?
All that's necessary is possession of the notice of assignment. And then the supporting collateral and obligations arising from the notice of assignment. I have Commission Express has priority in under UCC 9322 subsection C.
Okay, let's hear from respondent, and then you can respond.
Thank you, Your Honor. My name is Joseph Rothstein from Madelon PLLC, and I represent the respondent in this action. As the court seems to have noted, what was in dispute in this interpleader action was ownership of the commission account itself. The court below correctly determined that under UCC 9-322, as to the ownership of the commission account itself, the rule was first to file rule, and that was the rule. we're now being told that UCC 9-330 should apply, but they're not applying it to the commission account. They're applying it to the notice of intent to assign. And if you read the words of the provision, it says a purchaser of an instrument has priority over a security interest in the instrument perfected by a method other than
all
possession.
they have a notice of assignment
Correct.
given by Shannon to Commission Express. If that sort of notice of assignment was to give them priority over all prior filers of UCC1 statements, you would undo the whole system of priority.
Correct, and that was the point we made in our last point in our brief. We completely agree that the system would fail if, in fact, UCC filings could be overcome. But in this case, the argument actually fails for an even more basic reason, which is no one is disputing that Commission Express owns the notice of assignment. That's non-dispute, and therefore 9-330D simply doesn't apply to this dispute. The only thing in dispute is who owns the commission account. And as to that commission account, up until recently, Corcoran was the party that held it, but they were the only party that agreed that they didn't have a right to it. And so they came to the court asking the court to figure out who amongst the group deserved it. And in that debate, the court correctly applied the first to file rule. And then that does go to Your Honor, Judge Friedman's point, which is that's what the court had to do. It had to look at the UCCs and figure out who filed first. And so again, under 9-322, we win. And as to Appellant's argument about UCC 9-330, it simply doesn't apply because there's never been an argument about who owns the notice of assignment. If there are no other questions, I will rest on my argument.
Thank you.
Counsel, this is Judge Scarpello. I just have one question for you, which is, how do you respond to your adversary's argument that the instrument is the security interest and not the commission?
So again, I go back to 9-330, and what it says is the purchaser of an instrument has priority or security interest in the instrument perfected by a method other than possession. So there's never been a fight over who owns the notice of assignment.
But you're saying is not the instrument, right? The commission is the instrument.
It certainly is I apologize. It certainly is an instrument, but it's not the instrument that we're actually fighting over. No,
okay, let's hear
Middlegate never claimed the interest in that notice of assignment.
To state that another way, everyone can agree that Commission Express has the interest, it has the notice of assignment, but it doesn't do it any good because what matters is the actual commission.
Correct, exactly. And as to that, UCC 9-322 says first to file is the rule.
Thank you. Let's hear from Appellant now.
The only problem with the respondent's argument is that UCC 9322 is subject to 9330, and it specifically says that in subsection C of UCC 9322, and it says security interest in collateral which qualifies for priority over conflicting security interest under section 9330 also has priority.
It have to be the same security interest. You're mixing apples and oranges. One is a security interest in the commission, and one is a right to a future assignment. They're not the same interest.
But in the assignment,
Express has over an actual security interest in the commission.
But it's a supporting obligation of the notice of assignment, and that's under subsection 3C rather of 9322.
You can always do a subsequent assignment and therefore trump over any prior security interest in the commission itself by doing a notice of assignment. That's your argument.
That's why you have to do it in good faith. And
thank you very much.
But how can you even argue, Counselor, that it was done in good faith here? Did you look to see if there were any prior UCC filings, or did you close your eyes? Did your client close your eyes to it, take the assignment, which is only, as my colleague said, a future right at closing to collect? I don't think you even meet the good faith standard here.
We do, Your Honor, because my client inquired with the debtor's principal about whether there was any outstanding liens against, and there was a
Did you
garnishment.
do a
of 10%.
UCC1 search? Did you do a UCC1 search? And
I don't
while I
believe
ask
that-
you the question, I do acknowledge that you have to have actual knowledge under the statute. So you're not obligated to do a UCC search. But when you say good faith, the question is, did you do a UCC search? And if you did, why didn't you find the Middlegate prior filed lien?
But Your Honor's right about the actual knowledge, but that's why my client inquired with the debtor's principal as to whether there were any liens and any liens being asserted against the commission. And there was a 10% garnishment.
Thank you.
Thank
The
you.
next case is Sigolofskaya versus New York City Transit Authority.
Good afternoon, Your Honors. May it please the court. Irina Kravchenko, I represent the appellants on this appeal. It is the appellant's contention that the motion court incorrectly granted plaintiff's motion for summary judgment on the issue of liability. The case law on this point is well settled, is that the evidence of negligence of the rear-ending vehicle may be rebutted by proof that the frontmost vehicle came to a sudden, unanticipated negligent stop. That is particularly true in a case where the following vehicle had a reasonable expectation that the traffic will
Counsel, is that
continue
really a correct statement of the law? Isn't the law that a driver of the vehicle ahead making a sudden stop standing alone is insufficient to rebut the presumption?
Your Honor, yes, standing alone, that is correct. However, in the context which is applicable in this case, where the facts support a reasonable expectation that the traffic would flow unimpededly.
But how is that? I'm sorry, Counsel, this is Judge Singh. How on Flatbush Avenue and Aviation Road in Brooklyn would your client believe that traffic will not stop? There won't be turns. This is not a highway where we've agreed with those kinds of arguments. But this is a very different scenario. No, this is a busy road where a drivers should anticipate that cars and vehicles in front will stop.
Your Honor, respectfully, the appellants disagree. I agree with you that it's a busy road, but the circumstances of this case are very different. This wasn't a typical rear end collision. What happened here, and plaintiff admits to this, she was in the process of turning from the roadway into a marina. Now, the marina is not governed by any traffic controlling devices. In other words, she's making a right and she can proceed all the way through. However, what plaintiff did in this case is she stopped, admittedly, in the middle of her turn. She indicated that half of her vehicle was inside the marina and the other half still remained on the roadway. And that was the unanticipated factor in this case because the operator, Mr. Williams.
Counsel, she said she was stopped for more than 10 seconds. That being the case, doesn't the vehicle in the back have an obligation to see what there is to be seen, which is a stopped vehicle on the road?
Your Honor, I respectfully disagree. It is the appellant's position that everything, in accordance with plaintiff's testimony as well, that everything happened back to back. Plaintiff indicated that she saw this bicyclist right before he was about to cross in front of her, which was a split second.
No, she testified that she was stopped for 10 seconds.
Your Honor, I apologize. I don't recall that mention. As far as it was my understanding, and I was addressing it specifically in my reply brief, is that plaintiff gave a significantly shorter recitation. It is the appellant's position that the plaintiff was trying to paint a picture as if this was some kind of a protracted situation, but plaintiff testified that.
Let's hear from respondent and see what they say, and then you'll get a chance to respond.
Okay, thank you.
Respondent?
You're on mute.
My apologies. Good afternoon. This is Alan Zachary for the respondent. I believe the justices have nailed down the appropriate points because this was not a case such as, an expressway where a truck runs into the bottom of an overpass. This was a situation where it was the bus driver should have reasonably anticipated that plaintiff's vehicle could have stopped. Even in the circumstances here, the evidence is that she stopped in order to avoid striking a bicyclist who was about to cross in her path. And her testimony is undisputed that she came to a complete stop, and it was only after the bicyclist had completely passed in front of her from one side to the other that she was struck from behind by defendant's vehicle. And that shows that there is plenty of time for the defendant to take proper actions, but the reason why he was unable to stop in time was because he didn't leave sufficient amount of space between the front of his vehicle and the back of plaintiff's vehicle. He testified at the time that he observed plaintiff's vehicle stop, his bus was only 1/2 to 1 car length behind the back of plaintiff's vehicle, which in itself shows that he did not leave enough space. And if there's no further questions, be happy to rely on it.
Thank you.
Your Honors, I would just like to point out that I did a brief search of the record here. I didn't see any mention of 10 seconds. I do see the testimony that plaintiff stated that 1 second passed between the time that she saw the bicyclist and she came to a stop, and then the duration of time between the cyclist passing and the impact was a split second. So we're talking about a much quicker situation here where plaintiff is driving. She admitted to the driver that she did not see the bicyclist in time. In fact, there's an admission in the record. And then she then, according to
Counsel, doesn't your client admit that he saw the plaintiff's vehicle making a right turn, suggesting that he was just too close to stop?
Your Honor, yes and no. He does acknowledge that he knew that the plaintiff was making a turn. However, under these circumstances, it is our position that there's at a minimum a question of fact as to whether he could have reasonably anticipated that she will complete this turn without stopping, because
so can I ask you, counsel, this goes back to the issue of whether, the expectation of your client believing that traffic will flow unimpeded. Are you aware of any cases on busy roads such as Flatbush Avenue that we've agreed with that position? This is, again, not a highway.
Your Honor, the cases that I cite in my brief are, I think they're comparable. They don't specifically deal with the circumstance. I think this case is unique because we're not dealing with plaintiffs stopping and going in traffic. She was about to get out of my client's way. She was pulling into the entrance, which, by the way, there were no other cars there.
Thank you very much. Thank you.
Thank you very much.
The next case is People versus Schmielwski, Appellant.
Yes. Good afternoon, Your Honors. Margaret Knight from the Office of the Appellate Defender on behalf of Maria Schmielwski. Ms. Schmielwski's conviction should be reversed because the prosecution failed to prove that she wrongfully took over $50,000 by making materially false representations. Every single doctor who examined Ms. Schmielwski concurred that she had a mental health related disability.
Counsel, wasn't the doctor's opinions, the record is clear, were based basically on the representations made by the defendant.
That is correct, but
so if those representations were false or somehow misleading, as presumably the jury in this matter concluded, then the opinions of the doctors don't have much weight, do they?
That's not accurate. The doctors were presented with evidence that not everything she said was absolute literal truth. In fact, Dr. Bardinelli was told in his final report in 2013 not to trust her account of the precipitating.
There's other pretty compelling evidence that the version of events that the defendant presented is not consistent with the facts. I mean, that she can't drive, that she can't go at it, she can't work, she can't do anything else. And yet then there's evidence that she's sort of in a housekeeper type of role by two people, which really completely refutes the version of events that she's been presenting.
It does not. I mean, the diagnoses that she had were focused on agoraphobia, these jobs she had, and we concede she should have reported the dog and babysitting income, but were in the houses of small trusted friends.
Yeah,
and
I'm
sorry, go ahead.
Go ahead, Judge Singh.
But it was more than that. She took cruises. She was going to nursing school. I mean, there are multiple misrepresentations here, correct?
We would disagree with that. With the cruises, she never misrepresented them. She went on 2 over the course of 6 years, and her husband testified that she was so scared she didn't even leave the room on one of them. That wasn't a misrepresentation. And as to not being able to drive, she actually told Dr. Bardinelli, again in the 2013 report, that she had gotten in a car accident that year and would not get out of the car until a friend was there. So he was apparently aware that she actually did drive on her own sometimes. There were also other florid exaggerations, seemingly florid exaggeration.
Let me
The
turn your
homeless-
attention. This is Judge Friedman. Let me turn your attention to another issue in the case before your time runs out. The subject of restitution. What are the infirmities in the court's decision on restitution? if any?
Absolutely, Your Honor. I'm happy to talk about the court made no findings, and the court actually did agree that Ms. Schmielwski on page 7 of sentencing had mental health issues. And the restitution is different, even if your honors don't accept our definition of materiality, because 6027 sub 2 requires that the court look to the actual out-of-pocket losses. So there, the court would need to find that even if the doctors and OWCP had been aware of these so-called true facts, that she would have been entitled to no benefits whatsoever. And the record simply does not.
Counsel, this is Judge Scarpula. Did the defendant ever dispute the restitution amount?
No, but she was not required.
Did she ever ask for a hearing on her inability to pay?
No, but that is an obligation of the court, and I direct you again to 6027.
So, but the people put in some evidence, right? As to the restitution amount, it didn't come out of the air. She didn't dispute the people's evidence, and she didn't ask for a hearing. Is that all correct?
Well, respondent is arguing that our definition.
I'm just asking first. I understand what I want to hear what you argue. I just want to ask if those three things are correct. People put in evidence. She didn't dispute it. She didn't ask for a hearing.
The people put in evidence at trial as to the payments from OWCP, but the court did not make the requisite findings that she would have been entitled to no benefits whatsoever. The jury did not find that. And 6027 says if the record does not contain sufficient evidence to support the finding or upon request of the defense. So there's no burden on her to request.
Let me just ask you, there is evidence in the record of how much she got at the same time that she was working, right? She was actually working. She was getting disability payments at a time when she was actually working. There's evidence of those numbers in there, in the record.
There's evidence of, yes, approximately $25,000. So perhaps the court could have ordered restitution of $25,000, but the court didn't make the factual findings that are required. And that's why we're asking for a hearing where the court actually determine the out-of-pocket loss and make clear factual findings on the record.
Well, counsel, didn't the jury make that finding here? But basically, the theory of the prosecution was that she wasn't entitled to any of this money that was collected because she feigned her condition. That's what the jury apparently accepted, and that's what they voted. So why should that be disturbed?
The jury's finding was that she took over $50,000. It certainly was not $192,000, and there was no. I mean, it was a general verdict of guilty or not guilty, so there was no findings by the jury as to. But there was also no theory submitted to them.
There was also no theory submitted to them that that she was somehow entitled to any of this restitution. So it's reasonable for us to infer, based on their verdict, that they bought the prosecution's theory that she wasn't entitled to any of the $193,000 that she received.
We obviously disagree with that, but the
time of reply. You can have time. Let's hear from a respondent now.
Good afternoon, Beth Cublin for the people. May it please the court. Initially, all of defendants' arguments are unpreserved and should not be reached by this court in the interest of justice. But regardless, as to the
counsel, this is Judge Scarpula. I just want you to address. Is there evidence in the record? Because Casalvo says if there's evidence in the record for the out-of-pocket losses, then the court can rule on that. But let me ask you this. Is there evidence of the number that the lower court issued for out-of-pocket expenses?
Yes, Your Honor, and that was the full $192,227. As was discussed, it was the people's theory of the case that defendant was not entitled to any of the benefits that she received, and that was due to a plethora of evidence and corroborating evidence as to.
This is Judge Friedman. this is Judge Friedman. That goes to the issue of the amount, but your brief really doesn't address the subject of whether the defendant is entitled to a hearing on ability to pay. You didn't really respond to that point in your brief. Why shouldn't there be a hearing on ability to pay?
Your Honor, trial defense counsel actually requested restitution as part of the sentence, and that was in an effort to avoid incarceration. That was what was requested here by defense counsel on behalf of defendant. There was no request made below for a hearing, and that is presumably because this is exactly the sentence that defendant wanted in order to attempt to avoid, but at least here minimize the amount of incarceration that she would face. So therefore, it was not requested, and it would not have been appropriate to hold such a hearing where this is exactly what defendant was actually looking for. Also, it was the people's theory of the case below that that defendant was not entitled to any of the amount at all. And the jury, as was stated through their verdict, agreed with this theory. And in summation, defense counsel did argue before the jury that defendant was entitled to some of the funds, and that therefore the people had not met their burden. The jury listened to this argument and rejected this argument in their verdict, which is clear.
Thank you. Thank you very much.
Thank you.
Okay, we'll now hear rebuttal.
While defense counsel acknowledged that the prosecution was going to request restitution and did not object to that, as respondent said, presumably because he was more focused on keeping Ms. Schmielwski out of jail, out of prison, defense counsel certainly did not concur that the full amount of $190,000 plus was appropriate. And I would direct your attention to People v. Baker, a case that was cited. In that case, the defendant pled guilty.
I suppose your point would be, counsel, yes, the jury found that the defendant took more than $50,000, and therefore that supports the verdict, but it doesn't mean that the jury found that the defendant took $192,000.
Absolutely, Your Honor. And as Your Honor noted before, the court did not find that Ms. Schmielwski had an ability to pay this. In fact, acknowledged that she probably did not. And for all of those reasons, this exorbitant amount of restitution is inappropriate in her case. And
Thank you very much.
Thank you, Your Honors.
Okay. Zagerson versus New York City Department of Education, Appellant.
Yes, good afternoon. May it please the court, my name is Brian Glass for Mr. Zagerson. This case exposes the lack of appropriate safeguards for paraprofessionals in the New York City public school system. In contrast to a tenured teacher who would have a right to a due process hearing, would be suspended with pay, and then ultimately have some kind of hearing in front of a neutral, Mr. Zagerson was basically suspended in March 2018, waited 1.5 years for an investigation to be conducted without any pay. In August 2019, SCI issues a report, and the principal automatically terminates him. He goes to his union. He's asking for them to proceed with some kind of due process hearing, and the union refuses to take it. So Mr. Zagerson has had. Well,
that was a chancellor's hearing. No, it wasn't a due process hearing. They could have had a hearing in front of the chancellor.
Well, he did everything he could to try to get to the chancellor, and then there would be an arbitration that follows. And many.
But then the union didn't want to pursue it.
The union refused to pursue it. He's actually at PERB trying to get them to pursue it, and he's stuck there. So the problem with this case is this is all based on hearsay, innuendo.
So, counsel, it's not in fact true that he had an opportunity to appear. He had an opportunity to be represented by counsel. He was heard as to the findings of the investigation. He submitted a written response to the report. The report was done by an independent investigation. So it's not the same process as with the teacher, but there was a lot of process in this case.
Well, there was no neutral that ever evaluated the facts of this case. The principal had initiated the investigation, reported to SCI, and he ultimately denied it. And so,
well, Counselor, let me stop you there. Is that an accurate statement? Because didn't he admit in the presence of counsel that he may have pecked 2 or 3 children on the cheek?
He did use the word peck, but in the context of is this discipline? I mean, this is something, we don't have any dates. We don't have any times. He's confronted by a principal. Remember, he's a Russian immigrant who has a very thick accent, and he's being told, by very sophisticated investigators, did you peck, did you kiss, without any context, without any dates. We don't even know the parent who started this. We don't even know if the parent really started this or the principal put them up to it. You have nothing in this record. I'd like you to look at the end of this record of what the SCI investigation was. It was 2 statements. There were adults in the room at every moment. Remember, he's a one-to-one paraprofessional, so there are adults, there are teachers in the room, and they don't take any statements from the teachers. They don't even the one statement from one adult they have, which is also hearsay.
From Miss Donnery, Miss Donnery says that who was in the room with him, says she didn't witness any inappropriate behavior, and the fact is, it appears that Miss Donnery and the petitioner were in competition as to who was going to be accessed. Exactly. And Ms. Donnery had every reason to hope that the petitioner was out of the way. And she herself says she didn't witness any inappropriate behavior.
And you actually in the record, he put in letters of recommendation for some of the teachers who said he was an excellent paraprofessional. So again, this kind of spins out of control.
And the principal called the police down to begin this as a criminal investigation, and the police officer refused to arrest, citing lack of evidence that a crime had occurred.
Correct. So again, this is how things could spin out of control. Now, if this gets to some arbitration, I think some neutral could hear this, or if this is remanded back for a factual hearing, I think this falls apart very easily. I've seen this happen with other paraprofessionals.
But of course, your difficulty is that we're dealing with an Article 78 proceeding, and that's a very tough burden for you to overcome.
Thank you, counsel.
Thank you.
Good afternoon, Your Honors. Lorenzo De Silvio for respondents. 4 points dispose of this appeal. First, as Justice
I would like to ask you, Mr. Yes, Lorenzo, Judge Friedman, I have a question. I believe it's page 243 of the record, or at least the bottom of the document bears that number, which has one of the witness statements.
Yes, Your Honor.
And here the petitioner is being charged with having kissed 3 children on their cheeks. And the witness statement, it says, as best as I can read it, and that legibility is difficult, but it says, and what's handwritten by the child, that he kissed my head, page 243 of the record. So the very evidence which gets this started sort of contradicts one of the central points of the case against the petitioner, in addition to the fact that Ms. Donnery, who is probably almost certainly no one with sympathy for the petitioner, says that she, who's in the room, says she didn't witness any inappropriate behavior.
So 2 responses, Your Honor. First, whether it's head or cheek, I don't think that undercuts the severity of the misconduct here, because we have a paraprofessional who, with 3 different students, age 6, 7, and 8, kissed them on the cheek. He admitted to doing it with 2 out of the 3 students before SCI with his attorney present. He even admitted that he paid attention to the 3rd student, even though he was not assigned to work with her. So to the extent there's no independent value to what the other paraprofessional said, he admitted it to SCI.
Was that the student that there was one of the students was a Russian student who had language problems, and he was helping her out?
That is what
one that you're referring to?
Yes, that's correct, Your Honor. But regarding your other point, Your Honor, here Zagerson has never really drawn any connection between, his supposed failure to be given the statements, even though the objective evidence reflects that he did receive the statements. He had the SCI report. He had his attorney with him for a meeting with SCI. He had his union rep with him for 2 meetings with the principal, an additional letter. Not only did he admit to some of the conduct and fail to deny it with the principal, but he knew the names of the students. He knew when he would have been interacting with them. He knew it would have been in a small DOE classroom where there were max 3 other adults and max 23 other students. He alleged this on page 25 of his petition. If he really didn't know how to mount a sufficient defense, but for specific dates, why is it that he knows how many people are in the room regarding the alleged incidents? And again, there was a good and sufficient reason for his termination, given that He commented on the first student's smile and then immediately kissed her on the cheek. The second student reported that he grabbed her by the arm, thus she couldn't even get away. So not only is it inappropriate conduct that a paraprofessional should not be engaging with young students, it's also something of a physically aggressive behavior. And so DOE had good and sufficient reason, the language under the CBA here, for termination. And again, Zagerson had multiple opportunities with all of the information at its disposal to mount an adequate defense. And it's not until this Article 78 petition, and in some instances, briefing in this court, that he's even complaining about some of the things, including his choice of the word peck, which, as far as I'm aware, he introduced into the conversation with SCI.
Thank you very much. I have 1 minute for rebuttal.
Yeah, just this is indicative of an attempt to, there's no objectivity to this. This is the spinning of a record. There are no dates and times. Why? Blame the victim for everything, or blame Mr. Zagerson for everything. Where are the dates and times?
Do you have a federal action pending also?
We're trying to get some due process, and there is a federal action pending with it's stuck in a motion to dismiss right now. But the reason is because I want to get the principal under oath to testify, because this will come apart very easily when we start asking him questions under oath. Again, the problem is when she's protected by paper and the DOE, this is what happens when you don't have any due process. When you don't get a neutral to ask real questions. Even let me just step into its last point. In the city's brief, they represent that he had the witness statements before. The only reason we got the witness statements is because we filed the State Division charge, and then the first time the DOE decided to give us the witness statements. And if you look at the witness statements here, they are so pathetic. We finally get Ms. Donnery's statement where she saw nothing, and we see 2 witness statements that are illegible from 2 students, and we don't even know how the parent even made the complaint. So
Counsel, thank you very much. Thank you.
Thank you very much.
The next case is Tooley versus Cabgram Developer.
Good afternoon, Your Honors. If you may please the court, my name is Joseph Zilmanowitz, and I represent the defendant appellant Cabgram Developer, LLC. The purchaser contracted to purchase a condominium unit for approximately $1.8 million and gave a contract deposit of $465,000. The issue in the case was the return of the deposit, because the question is whether the purchaser, who is the plaintiff here, complied with specific conditions that are set forth.
If you got more discovery, which is what you're seeking in this case, how are you going to controvert the express letter from the bank explaining in more detail why the mortgage was rejected?
Well, number one, Your Honor, it's a good question, but the answer is that the letter is contradictory. The submission by the bank before that in May of 2019 set forth the reasons why this mortgage was denied.
So the first letter is a form letter. The second letter is a detailed subsequent letter explaining exactly why the mortgage was denied. And there's a representative from the bank saying in detail, how are you going to controvert that with further discovery?
Because we wanted to take the deposition of that author of that letter. Something is very strange here, and let me just put it to you.
Do you think that he's going to say it's not true? I didn't really mean what I said in the letter. I was misrepresenting in that letter.
How does somebody in a bank 6 months after they issue a letter saying there's no income verification, there is more problems with this mortgage, 6 months later in a letter to Mr. Tooley's litigation counsel, not to his transactional lawyer, because they asked for that 6 months later, and writes that letter? It's not done on the spot. It's not authenticated, that letter. It's inadmissible, and it's a letter that shouldn't be even used here for summary judgment. Now, the court below did not even refer to that letter. Instead, what the court said—
But isn't, counsel, is the affidavit, is the doctor's affidavit sufficient to establish the prima facie in this case?
I would submit to Your Honor that it is not, for the following reason. This is not a simple mortgage contingency clause kind of case. In this particular contract, the mortgage contingency rider specified 4 conditions which Dr. Tooley had to satisfy in order for him to get his money back. Those conditions are that he complied with the bank, all of the bank's questions, all of the bank's requests for information.
Counsel, we're familiar with the clause, but what evidence is there in the record that you've created an issue that they have not been complied with? Because it does appear that that subsequent letter from the bank satisfies all of those requirements along with the affidavit of plaintiff. So what do you bring to the table to raise a disputed issue of fact as to that, Chairman?
This is particularly where this court before has said that CPLR 20, I'm sorry, I just forgot the provision for a second, 3212F
Counsel,
applies.
3212F, again, this is Judge Scarpula, but okay, what do you think there's, other than you think for some reason the bank person who submitted the letter is going to say, actually, I lied. Other than that, what is it that you think that you're going to find?
Well, here are the contradictions in all the bank's communications. Number one, the first mortgage that the preliminary approval said there was a mortgage for $2 million. $2 million,
right. But let
not
me just say that
1.8.
that's before, if you look at that letter, it's again, a form letter who says to every proposed borrower, we think this is how much you're going to get, but we're not going to tell you that. We have to look at your numbers. We have to look at your everything else. I mean, it's basically like someone saying you can indict a ham sandwich. You can get a bank to say, I'm preliminarily telling you I'm going to give you $2 million pretty easily. So that put aside, it is not a commitment. It's
the wrong number.
Given what you've showed us today, this is what we think we can give you, correct? Let's agree on that. That's not a commitment. This is, here, Barbara, given what you sent me, I think I can give you this, but I need to look at your numbers. I need to look at everything else. So that's not really contradictory. It's just a bank trying to get the borrower to pay the $2,000 to get to make the application. So that's one. Then what's next? Then there's the form letter that says everything in the world. You didn't get this a mortgage for every single possible reason.
That's not true.
Then there's a specific letter.
There's only 2 reasons, Your Honor. There was only 2 reasons or 3 reasons of all that checklist that they said. And they said because you didn't have enough income, and also we couldn't have answers to our questions. That's basically what they said. Now, then you come up with a third one, not within that month, 6 months later, to the transactional attorney of Dr. Tooley. Those are questions. There's only 2 people.
We also don't know, this is Judge Friedman, the pre-approval, we don't know what the plaintiff submitted in order to get that pre-approval because there's been no discovery. We're making assumptions. Did he submit his tax returns? Based on what information did they decide to give the pre-approval?
That's exactly the point, Your Honor. And even the other side, Dr. Tooley's counsel mentions that on page 5. We don't know what the bank had in mind.
Let me hear from Respondent, and you'll have rebuttal time to further develop that point.
Thank you.
Thank you, Your Honors, and good afternoon. I'm Mark Held. I'm speaking on behalf of the Respondent, Dr. Tooley. I'm happy to answer.
So is this pre-approval for even more than the mortgage contingency is for? Based upon what is that pre-approval given?
A pre-approval letter is given to any prospective person that goes to a bank and say, is it possible you'll give me a loan someday? If Your Honor looks at the pre-approval letter, it specifically says in the pre-approval letter, it's just for credit worthiness and for nothing else. There's absolutely no value.
So credit worthiness means there was some sort of an investigation made as to his credit worthiness.
Usually it's a search of your FICO score or a credit score. Do you have a 750?
But we don't know. But we don't know because there's been no discovery.
And the pre-approval letter is irrelevant. It's not
Is the mortgage application and the supporting documentation part of the record on appeal?
It is. The mortgage application is not part of the record of appeal, but the mortgage application how about
the supporting documentation? Is whatever was submitted for that application, is that part of the record on appeal?
It is not, Your Honor. And the reason is because the appellant didn't put it as part of his record. The appellant's counsel now is not the first counsel in this case. The first counsel and I try to resolve this. This is where that the second letter, the November 12, 2019 letter came into be. Their attorney said, give us the supporting evidence as to why he acted in good faith and why we should return the money. So they asked me to go back to Citizens Bank and get them an explanation of that pro forma or computer generated letter. So we went back to Citizens Bank and they kindly provided a letter saying that Dr. Tully acted in good faith, acted with diligence, provided everything we asked for, was extremely cooperative. And the reason why we didn't give him a loan is because the amount of income to his debt didn't satisfy the bank's requirements. That is more than any documentation I've ever seen on a mortgage contingency case before this court. And the lower court thought it was sufficient enough to grant summary judgment. And in this case, the appellant never brought a single ounce of evidence to contradict or create an issue of fact.
But counsel, this is the judge saying, how could the appellant and do that? Because the information is not within the possession of the appellant, it's within the possession of the bank.
Well, we exchanged 1,400 documents with the appellant. The entire mortgage application, the emails, the financial records, they had it for 6 months before we even filed a lawsuit and almost 2 years to date. And not a single page of that mortgage application.
Wait a second, counsel. This is Judge Scarpua. So, for example, if there was a question that they put in a false statement in the mortgage application, the other side would have seen that because they had all those documents, correct?
That's correct.
And they never raised anything. They never said any of what the borrower submitted to the bank was false or inappropriate or not sufficient, right? They know exactly through what you gave them what the borrower submitted to the bank.
That's correct. And
so this is really just, and I want to find out who did the letter to ask her whether she was lying. That's the only discovery that's left.
That's
because they've gotten all the other things they've got the mortgage application, they got everything your client sent to the bank, correct?
Correct. They even got a response from their subpoena from the bank as well, according to the emails that were sent to us.
Okay.
Counsel, that November 12th letter, is that admissible? Should we be considering that letter?
Yes, Your Honor. I think it's admissible under the Picara case, which specifically says a party can prove a prima facie entitlement to summary judgment through the affirmation of its attorney based on documentary evidence. That letter was written to me, addressed to me, based on the request of not just myself, but appellant's original counsel.
Was it a joint request by counsel, or was it your request?
I spoke to him on behalf of both of us.
Well, did the letter say it was jointly requested? When you spoke to the bank, was it a joint request or your request?
The letter is addressed to me, but it was a joint request, hoping I would avoid this litigation so we can get the money
a joint request, between you and who else?
And the original lawyer was Kramer Levin, Your Honor, and it was based on the appellant's original law firm and I trying to resolve this without litigation.
Okay, thank you very much. Let's hear from appellant for rebuttal.
Yeah, Your Honor, very quickly, nothing of this is in the record. I'll note that if you look at page 71 of the record, that letter is written to Mark Held, which is my esteemed colleague over here. Not even a copy is noted.
Counsel, what documents are you seeking that you don't already have? I got originally the impression that you didn't have a single document. So you have you have the loan file.
No, we do not. No, we do not have nothing from the bank. That is a false statement.
No. Okay. I'm not saying that you have it from the bank. You have from the other party to this litigation. What is the 1,400 pages that you have?
We don't have 1,400 pages, number one. Number two, many of it is just duplicative things that don't show what the bank exactly was asking for when they sent out their May letter, which is that we can't verify the income. We want to know what happened between Dr. Tully and the bank. What happens in a mortgage process is the bank then sends its representative.
We're familiar. Counsel, your time's up now.
I know what happens in the mortgage process.
Thank you very much.
Thank you, Your Honors.
The next case is People versus Ramos.
Good afternoon. My name is Elizabeth Vasily, and I represent appellant Mr. David Ramos. May it please the court. At a minimum, this court must remand for a Wade hearing or even a brief inquiry of the witness to determine whether the out-of-court identification was police arranged or spontaneous. Additionally, the out-of-court identification should have been precluded because it was not properly noticed by the prosecution, and the testimony at trial indicated that it was not spontaneous. Instead, this out-of-court identification was disclosed on the day of trial.
What here makes you think that this is a police arranged identification?
The witness testified at trial. He was asked, quote, "How long are you standing outside watching what is happening?" In response, the witness responds,
but when
quote,
the defendant is brought out, doesn't the witness blurt out, "That's him," not in response to any question? He volunteers that.
He testified that he was waiting, quote, more than 45 minutes because he didn't come down right away. And even if he blurts out that's him, the fact that this was a police controlled situation because he was waiting alongside police officers.
Is the test police controlled or is it police arranged? The police didn't arrange Meekin's identification of the defendant.
In Dixon, Your Honor, the Court of Appeals makes clear that it is the police control of the situation. So, for example, this case is akin to Dixon, where the police were driving the witness around a car, not for the purpose of identification, but just driving him around the car, and he blurts out, "That's him," and the Court of Appeals found that that was police arranged. And this is exactly the same case.
That was the case where he was being driven around to look for the person who allegedly committed the crime. There's no arrangement like that here. It's not like the police were taking him around to find the person. So I don't understand how that case is comparable.
In Dixon, the court, it specifies they were canvassing. It wasn't specifically to look for the witness necessarily.
Something like that in this case. There's no canvassing. There's no extra step or anything the police were doing to generate that identification.
Just waiting with a witness for a prolonged period of time for 45 minutes and then having the suspect come down in front of him, the police can't play dumb and say, "Oh, we had no idea he was going to blurt that out." I think that that's what's expected to happen.
Counsel, when this emerged at the trial, defense counsel had an opportunity to further develop this issue and didn't take that opportunity.
Your Honor, he requested a Wade hearing. He requested a brief inquiry not in front of the jury. I think Your Honor may be referring to how the court said, well, you can do whatever you want on cross-examination, but I'm not going to grant you a Wade hearing. And that's just drastically different being in front of a jury. The defense counsel can't ask all the same questions that it would ask in a private setting. And so he wasn't allowed that proper opportunity. But in fact, it's really just, if there's any question, if this isn't a slam dunk, spontaneous witness flagging down the street, this should have been at least a threshold to have that hearing, to have that brief.
Counsel, I'm sorry to interrupt you. This is the judge saying, let's assume you're correct. For the purpose of this question, ultimately, isn't that harmless error here? Isn't the evidence overwhelming?
It's not, Your Honor. This is a single eyewitness identification case with no other direct evidence linking Mr. Ramos to the firearm.
So a gun comes out a window. Mr. Ramos jumps out a window. Is there enough evidence for the jury to conclude, in fact, that the gun came from the window Ramos was in, et cetera?
There isn't, Your Honor. There's multiple units in that building. Someone could have fired the gun outside of Mr. Ramos's window and run into another unit. There was testimony that there were multiple people, multiple men who resided besides Mr. Ramos in that building. It's just a drastically different case to have the eyewitness say, that's the guy that shot the gun, versus this no DNA on the gun, no other statements, just a circumstantial evidence case.
Let's
so
hear
it's
from
not.
and then we'll get a chance for rebuttal. Thank you.
Good afternoon, Your Honors. Diana Wang for the people. May it please the court. With respect to the Wade hearing, there is no evidence that the testimony, if it could be called an ID at all, was police arranged. The witness said that after he spoke to the officers, I continued to take my garbage out. He testified that he lived across the street. He worked across the street as a super. He was taking the garbage out when the shooting happened. So after speaking to the officers, he continued to take his garbage out. That indicates that he went back to work, AKA across the street, to finish taking the garbage out. And then several questions later, he was asked by the prosecutor, how long were you standing outside watching what was happening? And he said 45 minutes because he didn't come down right away. The question was not, how long were you standing with police officers? The question was, how long were you standing outside? And the super lived across the street. It's natural for a witness to a shooting to stay curious about what happened and maybe even cross the street for a closer look if he thought the police got the guy. But I'm sorry, I thought there was a question. But short of any instruction from police officers that you stick around, that we're going to ask you to make an identification, there is no police arrangement.
How do you respond to your adversary's argument that in effect the police were in control of the situation, so it was sort of a controlled ID, I guess, of some kind by the super?
That is belied by the testimony in trial because the witness said that he went back to his work duties after initially telling the officers what he saw. So there is no indication in the trial record that the police told him or controlled him in any way by saying, all right, you stand right here until we get the guy and we're going to make you an identification. There's no indication the police officers even asked him to go to his work duties and come back. And if, as your honors pointed out, if defense really wanted to explore that on cross-examination, the court told him you were free to explore that. And at the very least, defense counsel could have said on cross-examination, were you asked by a police officer to stay around to make an identification? Were you asked if that's the guy that you saw making the shooting? And that would have been the opportunity for defense counsel to elicit something that would indicate this is police arranged. And once that testimony comes out, that would have been defense counsel's opportunity to
But
say,
wouldn't the better procedure have been to hold a Wade hearing under circumstances? Because counsel's point's well taken. What you question in front of jury and what you question outside the presence of the jury is very different, right?
that's right, Your Honor. But the Wade hearing is only required when there's any aspect of police arrangedness to an identification. And if there is no aspect of police arrangedness, there is no need for a showing. So if defense counsel had simply asked, were you asked by the police officers to make an ID? And he said, yes, you can stop the cross-examination right there. You can ask the court at sidebar, hi, Judge, I think now the testimony has indicated there's some police arrangedness going on here, and now I would like a Wade hearing outside the presence of the jury. That would have been the correct procedure to go for here.
Okay, thank you, Judge Counsel. We'll hear from a rebuttal from appellant now.
Evidently, because there was factual dispute, and this wasn't an obvious case like a confirmatory ID where they're brothers, so obviously they're familiar with each other, there was a factual dispute. There should have been a hearing, and Dixon itself advises, quote, without the benefit of a Wade hearing, the courts below could not conclude as a matter of law that the witness's identification of the defendant was spontaneous and not subject to any degree of police suggestion. So in the least, this court should remand for that hearing, a brief inquiry.
Counsel, what's the conflict of fact? I still don't understand where that's coming from. There's nothing indicating that the eyewitness was controlled or instructed to do anything in particular by the police. So under the circumstances where the eyewitness speaks to the police, then goes about his business and happens to be there when the police are taking the suspect out and makes a spontaneous statement, what's in conflict?
His testimony that he was waiting for 45 minutes because the suspect didn't come down right away indicates that it really wasn't.
How does that make it police arranged? If he waited 45 minutes, if he waited 3 days, he decided to wait. Maybe he was nosy. Maybe he wanted to know what happened. Maybe he wanted to know if someone got apprehended. How does that make it police arranged?
With police officers bringing down a suspect with their presence outside the building, this is not a witness running down the street flagging a police officer. He's under the general control of the police. Additionally, I would like to direct the court to my point one in my brief as well.
Counsel, your time's up now. Thank you.
I would submit on my brief. I would refer to my brief then for point one on the amendment indictment. Thank you.
Okay, thank you. Resolute versus New Indy. Appellant.
Good afternoon. This is Melissa Holsinger on behalf of Appellant Resolute FPUS. May it please the court. The lower court erred when it declined to dismiss New Indy's third and fourth counterclaims, which are foreclosed by the plain language of the parties' asset purchase agreement. Under that agreement, New Indy unambiguously assumed future third-party asbestos liabilities when it bought a pulp and paper mill from Resolute.
Why couldn't there have been clearer language in this agreement? Why couldn't the agreement have just said one way or another? You know, because this is not a surprise that there are asbestos actions and that they were ongoing. Why didn't the agreement just say either we're assigning all asbestos actions, we're not assigning asbestos actions? Why do we have to go through this very circular, roundabout argument to find the answer to what is a somewhat crucial question, since asbestos litigation is vast and ongoing?
I think the answer is twofold. The parties, first of all, New Indy's assumption of liabilities was broad. It was broad at every turn. If you look at the liabilities that New Indy assumed in Section 4, 1.4, it assumed pension liabilities, all tax liabilities, all liabilities related to contracts.
Though, and this is why I'm asking this question, is most liabilities are somewhat known, where asbestos liabilities are sort of sui generis in the fact that they're completely unknown, and no one can predict down the road how many asbestos litigations would or would not be brought in the future. It could be thousands, it could be 100. Why? Because it is such a big, vast, unknown obligation, why isn't there more explicit language and clear language defining whether it's an assumed or retained obligation, acquired or retained obligation?
I can't answer the why there isn't something more explicit, but I will say that it is, although it is somewhat complicated to read definition upon definition to drill down, asbestos is referred to in the definition of hazardous substances. Hazardous laws relating to hazardous substances are included within the category of liabilities that New Indy assumed under Section 1.4.6a. So when you read all of the definitions together, as I said, it may be somewhat cumbersome, but it is explicit that they are in there. So there are 3 points I'd like to make today. The first is that New Indy assumed liabilities under Section 1.4.6a that arise under environmental law, which the contract defines.
Well, but how do you respond to New Indy's argument that only refers to statutes and regulation and not common law?
It applies to both. If you look at the language in Section 1.4.6 A, it refers both to environmental laws and to environmental permits. And the idea here again is breadth. Everything is swept in. Laws that can be enacted.
Law itself is defined on page 197 of the record as including common law.
Excuse me?
Law is itself defined on page 197 of the record as common law.
Correct. So law includes common law. Environmental liabilities arising under environmental law include thereby claims that arise under common law and that relate to exposure to hazardous substances, which is defined to include asbestos. So you've got, in those two definitions, Section 1.4.6a draws in both common law claims and claims relating to asbestos, which is precisely the category of claims we're talking about here. Secondly, there's a second provision of the agreement that applies, and that's 1.4.6c, under which New Indy assumed all liabilities relating to a release or other contamination or pollution of the environment. And again,
does that include asbestos? Release, I know, is broadly defined as any release. So you're saying under the general language that would mean anything into the environment, including asbestos, I assume.
The court doesn't have to consider the furthest bounds of what constitutes a release, but you'll see throughout the agreement, the parties refer to a release of hazardous substances again and again and again. And hazardous substances specifically includes asbestos. So you have the parties contemplating throughout the agreement that asbestos is something that can...
So it's a generalized argument when you look at the structure of the APA that the parties intended to include asbestos as well, then, correct?
Indeed, indeed. The lower court found that this, in fact, let me back up a second.
Counsel, this
Yes.
is Judge Garpool. Let me ask you, Are the asbestos cases that you are speaking about, are they exposures that happened prior to the sale?
Yes, Your Honor, we're talking about.
Okay, so you're saying the APA says, after I sell you the mill, whatever you release, whatever happens, wherever it goes, you're responsible for it. This release of asbestos happened prior to the sale, correct?
We're talking, correct. We are talking about cases where.
So what you assumed is what was passed was all the obligation for asbestos released into the environment after the sale, correct?
We're talking about cases that were filed or first brought post-closing, where
for release of asbestos that happened pre-closing.
Correct, where the exposure.
Why did they assume a liability for pre-closing release of asbestos when the documents say that you assume all obligations for your release of asbestos into the environment, right? Isn't that the way we're supposed to read this?
What you have is the parties setting closing as a dividing line. Resolute was selling the business and selling all of the liabilities associated with the business in virtually every respect. And was sort of washing its hands of these issues. And so closing is the dividing line. And you see that reflected in.
Well, that's supported, isn't that supported by the schedule, which, while Supreme Court pointed to that as creating an ambiguity, the cases listed on the schedule don't say they're asbestos cases. What brings them under your responsibility is the fact that they're pre-closing cases, without any indication that it's an asbestos case. And
exactly.
It's not only asbestos, and it's not only asbestos pre-closing cases that you undertook responsibility for. There's some non-asbestos cases there too.
Exactly, and what the schedule reflects is that dividing line I was speaking of. So all of the pending.
Let's hear from respondent now, and you'll get a chance to respond. Thank you.
Thank you, Your Honor.
Good afternoon. This is Julie Silva-Palmer for the respondent. May I please report? I'd like to start with the question that Justice Kern asked about why didn't the agreement say explicitly where the asbestos liability went. The agreement was structured so that the New Indy only assumed liabilities that were expressly itemized. Everything else was retained by Resolute. So the agreement wasn't designed to list every single liability that was associated.
Yeah, but when you go through the agreement, and yeah, look, it's certainly not a shining example of plain English, but when you go through the agreement, it becomes pretty clear that you're undertaking responsibility for post-closing asbestos cases. It's really, you go from 146A, you turn to the definitions, environmental laws, and laws, hazardous substance, and it becomes clear that asbestos, or even if you go under 146C, and when you go through those definitions, it becomes clear that asbestos is among those things that you're undertaking responsibility for, unless the case is something which has been specifically cut out, as it is in the schedule in 3.6.
Your Honor, the structure of the APA is actually the opposite of what you said. All of the liabilities are retained unless they're expressly assumed.
Right.
So, for example, if you look at the provision that you just mentioned, section 1.4.6C, there's a controlling court of appeals case that says that release in that context does not.
They're retained unless they're cut out, unless the liability is transferred to you, which is what 1.46A and C do when you look at the definitions when you get to asbestos cases.
Right. So let me address 1.4.6C first, which is what you're talking about. Under that provision, New Indy assumed a liability arising out of or relating to any release or other contamination or pollution of the environment. There's a controlling court of appeals case, Belt Painting, which we cite on page 31 of our brief, that talks about a circumstance exactly on all fours with our case. In that case, it concerned indoor exposure to paint fumes. And in that case, the insurer refused to provide coverage for that injury because there was a policy exclusion that applied to the discharge, dispersal, seepage, migration, release, or escape of pollutants at any time. And pollutants was defined to include, expressly to include fumes. So what the pollution exclusion did was exclude discharges or releases or seepage of fumes. And the Court of Appeals found that the provision was ambiguous as to the indoor exposure to fumes. And the reason that it said that is because it said that under New York law, the words release, discharge, and seepage, which are the same words that are used in the APA to define the term release, have, quote, environmental implications. Now, when we think about what environmental implications mean, people understand that to mean pollution outside of air, water, and land. They don't understand that to mean.
No, so isn't that undercut though by the specific definitions in this agreement, which are pretty specific? Everything's defined, and asbestos is pretty clearly defined to be covered under these provisions based on the definitions.
So you're referring right there to the argument.
I'm actually referring to 1.46A, which has pretty specific definitions.
Right.
It says that environmental law includes any and all laws relating to human health and safety, which is an asbestos term of art, as it relates to exposure to asbestos and asbestos-containing materials. So it's pretty specific in terms of the language that's used as it encompassing, and the same thing with environmental law specifically defined to include common law. So how do you get around that?
So those two provisions specifically, they're circular. So when it put to the side for
what's circular about the definition of hazardous substances, which specific, unlike the other provisions, hazardous substances specifically mentions asbestos.
Right. It identifies asbestos as one of many pollutants that are defined, classified under environmental laws. And when you look up the definition—
No, it's not defined under environment. It's under the definition of hazardous substance, and it uses the words means any.
Right. So the definition of a hazardous substance says that it means any waste, substance, etc., that is listed, defined, designated, or classified under environmental law. Now, under common law, asbestos tort claims aren't things that are listed, defined, designated, or classified under environmental law. And the way that environmental law and hazardous substances are defined is in the context of each other. So if you read the definition of environmental law, it refers you to hazardous substance. Hazardous substance refers you back to environmental law, and both terms are—
Counsel, you know, when this first broke out, the first 5 cases, certainly 4, I think it's 5, you undertook responsibility for these cases. It's then someone decided, oh, maybe we're not responsible for it. But your outlook on it, I don't mean you personally, the outlook on it was, yeah, this is the responsibility of the respondent.
Your Honor, with all due respect, our position is that that evidence on a motion to dismiss is not admissible. It can't be considered on this context. New Indy made a mistake. At this point, it realizes that it made a mistake and is trying to correct it, but it can't be considered part of the construction of the contract on a motion to dismiss.
Okay, let's get from respondent. Thank you. I mean, appellant.
Thank you, Your Honor. To address the last point about the 5 confirmations that New Indy signed and why we have put them before the court, those are documentary evidence that are perfectly cognizable on a motion under 3211A1. We are not asking the court to interpret an ambiguous contract or to look at them to determine what the party's intent was. What they do is reflect New Indy's acknowledgement 5 times post-closing that the unambiguous language of the contract required it to indemnify Resolute for asbestos.
But counsel, does that utterly refute the arguments raised by your adversary on this point?
If you look at the language, Your Honor, if you look at
I think it supports your position, and maybe it supports your position down the road, but is it something we should consider at this stage of the litigation?
I believe you can, I believe you should, but I don't think you have to. The language of the agreement itself is perfectly sufficient, perfectly unambiguous, and is enough on its own to hold in our favor. That said, the confirmation.
Besides, Supreme Court's reason for its decision was the schedule, and actually, under the terms of the contract, you're not supposed to look at the schedule if it conflicts with the terms of the contract.
That's correct, Your Honor.
That couldn't, under the terms of the contract, that schedule couldn't appropriately become the basis of a finding of ambiguity.
Okay, thank you very much, counsel.
Thank you.
Our next case is People versus Ugwu.
Good afternoon, Your Honors. Mr. Alfano has retired to a much warmer environment than here. I'll be arguing in his stead. I'm Harold Ferguson. When we come before this court challenging a suppression hearing court's decision based on the credibility of a police officer's testimony, this court defers to the credibility determination of the trial court because the trial court got to see the witness, got to see the witness's demeanor, got to see the witness's body language, and saw that witness subject to cross-examination. Here, we have a Rodriguez hearing where the complaining witness does not testify.
Counsel, don't we have law in the First Department that supports doing exactly that? That in a Rodriguez hearing, that prior knowledge may be established through the testimony of an officer without calling the victim? Why aren't those cases?
It can be, but under the circumstances here, where you have a 911 call, where at best the report that the complainant gives is equivocal as to whether she has seen the person, and an individual who...
Isn't she very clear though that she knew this person, that there's no question she knew this person? She saw this person numerous times. She knew about the cart. She knew that this person asked her for cigarettes. This is not someone that was unknown to her.
That is from a singular conversation that the complainant had with the police officer who testified. We know nothing about...
It may be a singular conversation, but the information it provided left little doubt that this was someone that Miss Bullock knew.
I disagree with you.
But let me stop you there, counsel. The statement was that the victim saw a defendant 2 to 3 times every 2 weeks for 6 months. That's a fair amount of times, no?
That would be if there aren't questions as to this individual's ability to perceive.
So now you're talking about the PCP.
They were talking about the PCP. We also don't know the type of lighting conditions. We don't know distance. We don't know any type of conversations that are being held.
We do know that
the distance wasn't too far, right? And the other times, presumably, she was walking by him.
Walking by, but we don't know the lighting conditions, the time of day. We don't know any of that. And what you have is
I know, let's understand what gets us to that point. And I know you're not satisfied with the content of that call, but this comes from a 9/11 call by the victim, does it not? So I think the guy who did it to me is in the park right now.
Your Honor, if she said it definitively, I see the person who did this to me. Instead, what she's saying is she's equivocating. I believe, I want to make sure. She's not making a definitive identification.
You asked her about that. You asked her about that in cross-examination, didn't you?
Your Honor, but that's not what's again. Well, we can't go to the trial record and impart it to the hearing court determination. That was not before the hearing court. All that's before the hearing court is the police officer. There's no way
That's the whole basis for your argument that she didn't definitively say that's the person in the park. That's the basis for why you think the court erred in not having a Rodriguez hearing?
The court did have a Rodriguez hearing, but our contention is that the police officer was not the proper witness in this particular circumstance, does not have enough information. And it is impossible here.
I'm sorry, Wade hearing, but go ahead.
Yeah, it's impossible here for counsel to properly cross-examine the police officer about the witness's statements. This is a singular statement that's made to the police officer in a single exchange after the individual has been arrested.
Okay, get your
That's,
point. Let's hear from respondent. You'll get a chance to reply.
Good afternoon, Your Honors. My name is Patricia Curran, and I represent the people on this appeal. I want to point out first that defense counsel's argument today is not preserved. Defense counsel did not argue below that the people needed to call the victim in this case to testify at the suppression hearing. And as the court has pointed out, that's hardly surprising because in People v. Lee, this very court decided that people were not required to call the victim at a Rodriguez hearing. Now, in addition to that, it is clear, as the court has also pointed out, that the court correctly denied the defendant's motion to suppress here. The officer's testimony at the hearing was more than sufficient to show that this victim knew the defendant such that she would not be susceptible to police suggestion. In that regard, the officer said that over a 6-month period, as informed by the victim, she had seen the defendant in the same general area of the park 2 to 3 times every 2 weeks, and that he would ask for a cigarette on those occasions. She had every reason to notice him. Obviously, she recognized him, as we find out during the incident, because she went up and said something to him that initiated this entire reaction. So there is absolutely no reason to question the court's finding here. In addition, this hearing was only, her identification was only police oriented in the most technical sense. She saw the defendant in the park and called the police and directed them to him. So there was really no suggestion of police misconduct here. If there are any other questions about the Wade hearing or about the expert point, I'd be glad to answer them.
Thank you very much, counsel.
Thank you very much.
Anyone have any questions? Okay, thank you very much.
Thank you.
You have 1 minute for rebuttal.
Well, the argument, it is preserved because counsel makes the argument that the evidence that the people submitted was insufficient to show sufficient familiarity. And as to that she recognized him, every time I walk from my office to 100 Center Street and walk past one police plaza, some police officer comes up and thinks I am the head of the PBA union because I look like him. So to say that she knows that a random homeless person in the park is the person that she has seen each time strains credulity.
But Mr. Ferguson, that's really unfair, isn't it? The testimony was 2 to 3 times a week. He asked for a cigarette over a 6-month period. Some differences, no?
Your Honor, again, it isn't 2 to 3 times a week. It says 2 to 3 times every 2 weeks or so is what the statement is. It's not 2 or 3 times.
Mr. Ferguson, I appreciate your reference to their mistaken identification of you, but it's not really the same situation.
Okay, thank you very much, counsel. Your time's up now.
If I could just address the final point.
Thank you very much.
Thank you.
Thank you. The next case, I'm going to go back to earlier in the calendar now. We're up to the cases where there was recusal. The next case is Priestley versus Paramedics, and Justice Singh is recused on that matter. Go ahead.
Okay, so I was waiting for the justice to remove this. Could disappear from the screen, I guess. I apologize. Jonathan Harwood on behalf of Appellant, Halkett Whites and Theodore Halketts. As the court is well aware, there are numerous issues here. What I'd like to start with, however, is one of the 2 remaining claims in this case is the tortious interference with judgment and the damages aspect of that, which we addressed in the court below. And it's our contention, and I think the evidence is very clear, that the damages sought by plaintiffs here are faulty in numerous regards. Primarily, they base their damage argument almost exclusively on the claimed value of a product known as C105 and the patent to that product. It's undisputed in the record in this case that at all times relevant to this case, when the judgment itself was sought to be executed, that that Paramedics did not own the patent to that product.
Is that in fact disputed, counsel?
It is not, Your Honor. There is
Isn't it
no,
disputed that if they didn't have any interest in it, then there'd be nothing to litigate about it. It's being litigated because they're making an argument that Pandemics did have some ownership interest or some right to it, which was collectible. Otherwise, the case would not be proceeding if that was undisputed.
well, that, I'll correct my verbiage. They may claim that, but the evidence shows that Pandemics had no ownership interest in C-105 in 2000.
So you're saying the court below was incorrect in finding that there was a disputed issue of fact as to whether or not Pandemics did or did not have an interest at that time?
The court below didn't even acknowledge the issue, Your Honor. They didn't address it.
Well, why counsel issue of fact? I'm sorry. Ask something, Judge Capullo.
I just want to ask you, are you saying that it's undisputed that they had no interest in the product or they had no interest in the patent?
They had no interest in the patent or the product itself. The only
Either one.
Correct. The only connection that Pandemics had in 2009 was that it was performing testing on that. It had no ownership interest whatsoever in that product. So if
we're not talking about the product. Put the product aside. You're saying they didn't file an application for a patent. They had no connection to any patent?
Correct. The patent was owned by a company called CNS at that time.
And is CNS connected to Pandemics?
No, there is no connection between the companies. The only
When did Pandemics get the patent?
Well, first of all, Pandemics never got full right or ownership in the patent. In 2013, I believe it was, as a result of an arbitration commenced by the Halkett-White's firm, they obtained a 10% interest in that patent. No more than that. 90% of that interest still stayed with CNS. Pandemics never had, that was at least 4 years after the judgment was attempted to be collected on. So if the plaintiff had been successful and collected on her judgment in 2009, she would not have had any ongoing interest in that product or any right to any profit in that product, which is what she's claiming here. And then, Your Honor, if even if we were to go beyond that issue, there are significant issues with the potential value, which again they're trying to establish damages based on the value of that product. The testimony in this case from David Erlanger, who was in charge of all the testing on C-105, is very clear, unequivocal, and unrefuted that in 2007, so 2 years before any judgment was even obtained here, or before the judgment was intended to be collected on here, that product had failed to reach its two primary endpoints in testing. As a result of that, while they were intending to pursue a second potential use that showed some promise in testing, they were unable to receive any funding for any further testing. And he testified that they repeatedly lowered their expectations on the amount of funding they were seeking to obtain to get some foothold, and they were not able to get that. In fact, his testimony was that their source of funding, quote, lost all interest overnight when we failed our trial, and that was in 2007, which ties into our other issue with the damages, that they are in whole unduly speculative and insufficient to support a claim of tortious interference here. Again, the damages they're seeking here are in the vein of lost profits, and the standard is very high in cases like that. You have to be able to prove your damages with reasonable certainty. Speculation and conjecture will not be accepted, and claims should be dismissed in those situations.
So, counsel, this is Judge Scarpula again. Assuming that their argument is that you did at least own that 10%, even though it hadn't been judicially or arbitrarily or through an arbitration determined, correct? And there is an argument that the patent was worth something in 2009, which was different from what it was worth in 2014. That's their argument, correct?
That's their argument, but again, we believe that the evidence shows that that's impossible to prove for a variety of reasons. Number one, as I said, being there was no ability to get any funding to establish that the product had any useful purpose whatsoever.
Well, I mean, so you dispute their experts' opinion. But that's not for us to decide, right?
I'm not disputing the opinion, Your Honor. I'm not talking about whether the product, what the value of the product may have been. The issue here is that there was no opportunity to determine if that product could even be used, and it never was used in any capacity or sold to
I'm not talking about the product either. I'm talking about the patent.
No, I
The
understand
patent
that.
has a value separate from the product.
But
People buy and sell patents, right?
certainly, but in a situation like this where the product showed no use, was no ability to test it for its any potential use, there's no credible or sufficient way to present evidence that would allow to establish the value.
Why would you go after 10% of the patent in 2013 if it was worth nothing in 2009?
Well, Your Honor, we weren't going after 10% of the patent. Penmedics was owed money for the testing work that it had done with the product. That was the nature of the arbitration. In fact, CNS, which owned the patent, defaulted in the arbitration, indicating that it certainly saw no value in the product. As a result of that default, that was the award that Penmedics received. But what it was seeking was payment for testing that it had done previously.
Wait a second, you didn't ask for 10% of the patent?
They sought whatever.
I'm asking you whether you asked for 10% of the patent, or somehow the arbitrator came up with that number out of nothing that you asked for.
I'm not certain, Your Honor. But
I'm sure you asked for 10% of the patent. I don't think that the arbitrator would just come up with that.
Well, it's time to hear from opposing counsel, so maybe you can elucidate on that.
Good afternoon. My name is Ira Levine. I represent the plaintiff appellant. Justice Scarpula.
Before you get into the other issues, is there any reason why White's individually doesn't the statute of limitations get him out of this case?
No. White's and
not the firm, him individually.
White's is in the case because the under the relation back theory, and as well as this.
But he wasn't a party to the action at that time.
White's was in privity with his firm. He was involved in the underlying litigation through his firm, as the court below acknowledged in its decision. And not only that, this court in 2015, when it sustained the amendment, essentially and in reality held that the causes of action were timely asserted, in the absence of which the court would have.
So that was a pleading motion. It wasn't a substantive motion. But what about the argument that although there is a unity in interest, there's no showing that the failure to name him individually as a defendant was due to a mistake as to identity, which is required for the relation back doctrine?
Well, I understand that, and obviously, if I understand your point, the question is, when did this cause of action, or when did these tort claims against the individuals accrue? And as we argued in our brief, not only do we have the relation back, but a mistake in fact is not the sine qua non of whether the relation back theory applies.
Isn't it a requirement though?
Not necessarily. Not necessarily in the context if you have the other elements involved in the argument, where there is a privity, where there's a unity of interest, where there is a notice. But I'd also like to point out,
unity of interest is enough, even where you can't make that additional showing, that just showing the unity is enough by itself for the relation back?
Yes, the unity of interest, the unity of interest, and the actual knowledge of the claim is enough, even if you want.
And you don't think you have to show that they were somehow mistaken as to not including them in the original complaint?
Well, the causes of action, Justice Kern, against the individual are the tort claims, and we submit that the tort claims were timely interposed because they did not accrue until after Judge
Why wouldn't they accrue in 2009, which is when the plaintiff was prevented from executing on the judgment?
But the cause of action didn't accrue until after there was a judicial finding that the security interest was.
If what you're complaining, the tortious interference is that we had a judgment and you tortiously interfered by transferring the security interest. So why isn't that 2009 when that interference actually occurred?
It could, but I would also argue that you cannot assert a tort claim plausibly for interfering with a judgment until after your security interest has been judicially determined to be fraudulent, to be a fraudulent conveyance.
Isn't that exactly what you do in the context of the lawsuit? Why do you have to get there's no requirement that you get a separate or judgment on that ground. You do it all at one time. You say that you wrongfully interfered. I mean, in fact, that's exactly what happened in the federal action, right?
Well, right, but by way
so
of
there's no requirement of a judicial finding for the claim to accrue.
But what I will, if I could give an analogy, and I recognize that analogies are always imperfect, a claim for contribution and indemnification does not accrue technically until after there's a payment on the judgment, although we can assert.
Is that a good analogy to the situation we have here?
Yes, I believe so. I believe so because there's a triggering event that has to take place. And that triggering event.
The triggering event was that they were precluded from executing on their interest, and that happened in December of 2009.
No question about it. But also the triggering event has to be the judicial determination that the security agreement was a fraudulent conveyance.
Okay, let's see.
May I just ask you about? I just want to ask you whether you agree that the defendant Penmedics had no interest in the patent in 2009.
No, I believe the record shows that they had at least a 10% interest in the patent in 2009. They had a real bona fide interest, and as a matter of fact, the deposition testimony from David Erlanger, which I cited in my brief, and I believe it's at page 1344 of the record, shows that there was value in the patent. And the expert affidavit of Dr. Zaleski points out that in 2009, this patent had value, whereas many years later, those 5, 6, 7 years later, that value was diminished.
Okay, let's hear from Appellant. Thank you.
Thank you, Your Honors. I would just quickly with respect to the interest in C-105, I respectively disagree with counsel. There's absolutely no evidence, and the evidence is in fact undisputed, that Penmedics did not have that 10% interest or any interest in C-105 at the time that the judgment was.
Why isn't that a disputed issue of fact, though?
Because plaintiffs claim that happened is not backed by any evidence. There is, and in fact, there's no claim of that in the record. Counsel is making that claim. There's no evidence submitted by plaintiff, either testimonial or otherwise, to that effect. There is evidence in the record of the exact opposite, that there was no such ownership, including by Mr. Comrie himself, who was the president and CEO of the company, as well as Mr. Weitz, who testified in this case.
Okay, are there any other questions from the justices on this case? Okay, thank you very much.
Thank you.
The next case is Mellon versus Mellon, and Justice Friedman is disqualified on that case. Okay. Go ahead, counsel.
Good afternoon, Your Honor. Robert Cohen is speaking on behalf of the appellant defendant in this case. Thank you for giving us this time. In March, in 2 months in March, this action will begin its 6th year. It was commenced in 2017. I believe this appeal is a very important appeal for this court. I recognize that all the appeals before this court are important, and I certainly recognize that for litigants, they're all important. We have a situation in the trial courts now where getting a trial is like being in quicksand. It is very, very difficult to get, particularly with respect to
the specific issue of whether or not the agreement to arbitrate is too indefinite to be enforceable or not.
Sure, and Judge Karn. So the agreement that came out of a September 2019 meeting that these parties had with their representatives was a 45-page document. Yes, that's the issue in the case. Was a 45-page document that was marked as an exhibit during the hearing that took place in this case. Not only was it marked as a document, in this case, it was also referred to by my colleague, Mr. Foreman, who will be on the other side of this.
Let me ask you something, counsel. Let me ask something, because there is a dispute whether or not that 9-4 draft agreement is the document referred to in the arbitration agreement, since nothing is attached. But even assuming that that is the document that's attached, doesn't the evidence in the record show that that 9-4 agreement was still actively being negotiated and was incomplete? So where is then the required definiteness to make it enforceable?
Judge, so here's the background on that. That agreement was not intended, it wasn't an acknowledged agreement. It wasn't intended to be an enforceable matrimonial agreement. It was intended only to be a guide for the arbitrator that was designated approximately 10 days later in the arbitration agreement, which came out as the next thing. It was not intended to be a final agreement, and that's where the court below, I think, made its error. They assumed that you needed a formal agreement. Well, there is a very, very broad arbitration provision. Frankly, it's the broadest arbitration provision I've ever seen. It says, irrevocably and unconditionally submit to the fullest extent under law all claims, and then it goes on for lines and lines of setting forth all the possible claims.
Counsel, let's go back for a minute, because it says, again, it's debatable whether or not it is even the 9-4 draft that's being referred to, because it's not attached, it doesn't refer to, but let's assume for purposes of the argument that it is referring to the 9-4 agreement. It says in the arbitration agreement that the parties have reached agreement on the essential terms attached hereto. But if that footstool is not present, that they haven't really reached agreement, isn't that a problem in terms of enforceability of the arbitration?
No, they actually did, Judge. They $35 million of equitable distribution. It was agreed to. Mr. Foreman, in a follow-up email, specifically referred to that. They specifically agreed, in view of the very large equitable distribution award, there was going to be no support. And they agreed to a variety of other issues. What they didn't agree to was what the composition of the $35 billion, what the real estate was going to go into, and what they didn't agree to is what my grandmother would call the tchotchkes, which was the personal property that existed here, and they didn't agree to that. And that was an issue that was going to go to the arbitrator, and any other issue. And if you look at that arbitration agreement, and it's on page 1306 of the record, you will see that it's a very broad, and it gives to this.
Mr. Cohen conceded that the arbitration agreement is broad, but wasn't there also testimony at the hearing that it was that the arbitration was intended to be limited to issues with respect to property distribution?
I don't believe that's the case. The 3 witnesses that were all found credible by Judge O'Neill-Levy all testified as to what the document was that they were going to be guided by. That was the language that the parties agreed to. They would be guided by that. And then 10 days later, they couldn't reach agreement on these issues. So what they did was they designated Rabbi Rudinsky a learned scholar in the Orthodox community, and they gave it to him to finish up. And that's not an unusual circumstance in arbitration agreements in the matrimonial cases.
What about the fact that it took place at 4 a.m. the day before the wedding?
Well,
what weight should be given to that in terms of deciding whether or not it was too indefinite to be enforceable, not real intent to arbitrate?
So Judge Kern, the 4 o'clock in the morning, we all work during the day. So working at night is a surprise to us. But to a lot of people, it's not. But having said this, there was a reason. The plaintiff, Mrs. Malone, the respondent here, asked for that meeting to occur. She wanted that meeting. Mr. Skydell, one of the principal people involved in the arbitration, was leaving the following morning at 6 o'clock in the morning. I think it was a Thursday morning. I'm sorry, a Monday morning. And Tuesday was when there was a wedding taking place. It was one of the subjects of this arbitration. And so therefore, the only time they could meet was at night for Mr. Skydell to be able to make his airplane. It was an unusual time, but we have to remember that lots of people work at night. We generally
don't. This is Judge Scarpullo. What about the trial court's crediting Mr. Groman's testimony that the wife didn't understand what she was signing, that he thought that the agreement was going to be something else that was eventually memorialized, and it was it was uncomfortable, that they were forcing her to do it. What about, the trial judge credited all of that testimony.
So I'm going to read what I have Mr. Groman testifying, Judge Scarpullo. And he testified that the attachment, which is what Judge O'Neill Levy found was missing, and she said it wasn't clear what it was. Mr. Groman testified to this question. Is it fair to say that the references the parties have reached an agreement on the essential terms here too, is the postnuptial agreement, that 45-page document that came out of the September 2nd meeting? And isn't that the agreement that was on the table? And Mr. Groman acknowledged it. The 3 witnesses that testified at this hearing, Judge Scarpullo, all agreed that the 45-page document was the document that they should be guided by.
I'm going to interrupt now because I'm sorry, because you've gone over your time, and you're going to have a minute for rebuttal, so you can further address this argument on your rebuttal time. So let's hear from opposing counsel.
Good afternoon, Your Honors. Thank you for having us. I'm Joshua Foreman, attorney for the respondent in this matter. The issues surrounding what Mr. Cohn said are not entirely accurate. Number one, he misquoted the amount of the settlement. The settlement was not $35 million. It was supposed to be $40 million leading up to the meeting. Then at the midnight meeting, there was an additional $20 million that was supposed to be put in trust. That was not, I can't hear, can Mr. Cohn mute himself? I'm sorry. And the court acknowledged that fact. The fact was that this agreement from September 4th that was emailed to me was not negotiated, was indefinite. It was just a proposal from
Mr. Foreman, I want to
attorney.
stop you there for a second. Justice Kern asked Mr. Cohn a question with respect to the issue, the provision that says the parties have reached an agreement to the essential terms attached here too, which is the 9-4 agreement. Was that agreement, were the essential terms agreed to in the 9-4 proposal?
No, the 9-4 proposal was simply an email sent from Mr. Cohn's counsel to me, and that is all. It was never commented upon. We never provided them any document, any comments whatsoever to it. Nothing was entered into evidence at trial. Mr. Cohn might be shaking his head, but he's incorrect. There was no negotiation of that agreement whatsoever. It was one party's, Mr. Malone's counsel, drafted a agreement and sent it to me. There were no comments provided whatsoever. It was not negotiated. It was not all of the terms. And in fact, that evening, the midnight meeting, additional terms were made to be put into the agreement. So it couldn't be essential terms were done because the essential terms were never finalized. And that's why that agreement could not be the agreement they're talking about. We don't know what agreement should have been attached. No one does.
Well,
Cohen
I
talks about-
think it would be a fair inference to say it's the 9-4 the 9-4 proposal, no?
No, because that's a proposal. It's an agreement that Mr. Cohen's own client, Mr. Malone, had never read. Mr. Malone's counsel, went in the cover email to me, it specifically said, this agreement has not been reviewed by our client. At trial, Mr. Malone couldn't identify it. The other witnesses that he's saying specifically identified it, one of the witnesses said, I can't read, I didn't read the whole thing. Another one of the witnesses says, Josh, you have to give me more than that, than just the page of the agreement. None of the witnesses conclusively identified the document that was attached to the 9-4 email as anything but a proposed agreement. They didn't even know the terms. Mr. Groman also didn't specifically say what Mr. Cohen says he said. What Mr. Groman's testimony was, as Honorable Kern specifically questioned Mr. Cohen on, Mr. Groman was credited as saying, if that is what the agreement says, the arbitration agreement, then Mrs. Malone didn't understand it because it's not what I understood it as. I understood it as the arbitrator was only doing one thing. The arbitrator was supposed to help them pick properties because part of the settlement in theory was cash, money in trust, and picking the properties. And the arbitrator was supposed to help them pick the properties. But the arbitration agreement didn't say that. This was the most poorly drafted arbitration agreement ever to have been seen by me. It was over 4.5 pages, single spaced, 8 font. It was impossible barely to read. There are blanks, there are inconsistencies, and incorrect items and terms within the agreement, and it should not be upheld for those reasons. And also, it's an agreement to agree. It specifically says there are essential terms attached. There were no essential terms agreed by the parties. Mr. Malone, again, could not identify the essential terms. If Mr. Malone couldn't identify them, my client couldn't identify them, how could there be essential terms? Also, talking about a 4 a.m. meeting, which Mr. Cohen in his reply affirmation said, oh, she could have had counsel there, counsel were available. I'm sorry, I am not available at 4 o'clock in the morning. I wasn't available at 1 o'clock in the morning when the meeting started. I wasn't available at 4 o'clock in the morning when the meeting ended. Additionally,
You mean to say, Mr. Foreman, you wouldn't have taken your client's call at 4 a.m.?
Unfortunately, no. I'm not allowed to have my phone in my bedroom, but that's really not the judge's problem. You know, it's a real issue here. You have to look at Mr. Cohen's papers specifically state Mrs. Malone should be charged with the agreement that she signed, an agreement that admittedly she had 18 minutes to review at 4 o'clock in the morning, very stressed out the day before her daughter's wedding, not knowing if the wedding was going forward. She is supposed to be charged with that. But yet Mr. Cohen also says in his reply papers that our argument and bringing this up to the trial court and the trial court deciding this shouldn't be allowed because Mr. Malone's team of 2 separate law firms, not Mr. Cohen's law firm, but 2 other law firms, only had 12 days to come up with opposition to this legal argument. How is that possible? That it's okay, the lawyers couldn't use 12 working days to come up with a legal argument, but yet my high school educated client had 18 minutes to review an arbitration agreement that the advisor that was there for her, Mr. Groman, says it doesn't even say what we think it said. Maybe they printed out the wrong arbitration agreement. It's possible. Look, these people did a graveman's job. They were trying to help these parties. I don't fault them for what they did, but the problem is the agreement that was printed and then later signed is unenforceable because there is no way to know what those essential terms were. I can keep going, but I think by the look I'm done.
Thank you very much.
Thank you,
let's
Your Honor.
hear
I appreciate it.
I'm gonna try to deal with this quickly. The whole 4 in the morning is a red herring by Mr. Foreman. Mrs. Malone, the following day at about 4 in the afternoon, notarized that document. During that day, during daylight hours, Mr. Foreman's firm spent 9 hours. Mr. Goldie is now on the screen, and I think somebody is missing. But during that day,
It's okay, they didn't call the case yet.
I'm sorry. During that, can you add a few seconds onto my time, Judge Kern? During that day, Mrs. Malone had all day to deal with the arbitration.
Okay, Mr. Cohen,
Our lawyers
I'm sorry, Mr. Cohen, I just want to interrupt.
Gotcha.
The issue really is what my colleague raised initially as to whether or not the arbitration agreement is enforceable. And I go back to the question I asked Mr. Foreman, is what are the essential terms agreed to that form the basis of the arbitration? It's pretty clear that the 9-4 agreement was not, it was just maybe an agreement to agree. It was a proposal. That was it. There was no underlying agreement. So isn't that, under those circumstances, isn't it indefinite?
It said that the arbitrator should be guided by the provisions of that agreement.
I'm sorry, record page, Mr. Cohen, record page 1416, quote, "The parties have reached an agreement on the essential terms attached hereto." That's the language that I'm focusing on. So with respect to that language, Judge Curran asked you the same questions. How is it definite when we know that the 9-4 agreement was, assuming it's the 9-4 agreement, there was no agreement?
There was a provision, Judge Singh, as I recall, that said the arbitrator was to be guided by that agreement.
So there's an inconsistency in the agreement itself. Then there's a provision that says you're guided, and then it says you've agreed to the essential terms. It says the parties have reached an agreement on the essential terms here too. The arbitrator will be guided by the agreement as drafted and modified by the parties. But don't we have to consider both sentences?
Yes, we do. But I think the arbitration agreement, Judge Singh, it is broad enough, like most arbitration agreements.
But then we go to the third line, Mr. Cohen. Any terms hereto not agreed upon shall be under the aegis of the arbitrator in a ruling. So that tells me that the arbitrator is going to decide only the items that the parties hadn't agreed to, correct?
That, as I read the arbitration provision, Judge Singh, in connection with the agreement, that agreement was not signed, it wasn't notarized, it was not a formal agreement. Nobody expected that that agreement would become the arbitration. They merely expected that the arbitrator would be guided by that agreement. And that was the purpose of the arbitration.
You had a lot of extra time, so that's, we're gonna call this argument over at this point and go on to our last argument of the day.
Thank you, Judge.
Thank you. The last case is Flowers versus 73rd Townhouse, and Justice Scarpula is recused on that matter. Counsel? Oh, I'm sorry. Okay. Go ahead. Is counsel not there?
Respondent is here, and I believe appellant's counsel is also here. He's currently muted.
I don't even see him on the screen.
I don't either, but I do see his name in the little circle.
Okay, here he is, I think.
Can you see me now?
Yes.
Sorry. Good afternoon. We represent the appellant in this matter. We believe that summary judgment was improperly granted, partial summary judgment on liability, that there are a number of disputed issues of fact regarding the debtor and creditor causes of action, regarding particularly the solvency of the townhouse owner on the date of the closing in November of 2000.
So how, counsel, did you raise an issue of fact with respect to insolvency? Did you have an expert review the documents, for example, and then opine as to whether or not on the appropriate date that the townhouse owner was in fact solvent?
Well, what we had was the affidavit of Mr. Rinsler that disputed the notion that there was a phantom loan that wasn't accounted for. And at the date of the closing, I think it's very important in terms of solvency, because you use a balance sheet analysis, that the purchase price for the townhouse paid all of the mortgage debt on the townhouse, paid all of the obligations on the townhouse, paid all of the closing costs on the townhouse, and generated monies for the 2 escrows that were deposited at closing. So the proceeds paid all of the debts. And I think one of the deficiencies in the decision below is they didn't properly apply the balance sheet insolvency test under the debtor and creditor law, which is assets above probable liabilities. All the liabilities were accounted for. The 2 escrows were dispersed pursuant to court order. And those court orders generated the surplus proceeds of $685,000, which is what is really in dispute. And they were dispersed. There was no stay of the distribution. The appellate division denied that. At the time of the closing, the claim for a price adjustment or a price abatement had been denied. So there was no outstanding claim there. There was a naked right of appeal, but there was no actual claim in existence. So on the balance sheet test, and I think that's what you're guided by, that there was no insolvency, or at worst, it's an issue of fact because Mr. Rizler did dispute this phantom notion that there was a collateral mortgage that was separate and apart from the original mortgage. What we explained in the court below is that this collateral mortgage of $500,000 was just that, an added collateral mortgage.
Was there, I know the statement was made in the affidavit, was there more proof submitted, the mortgage underlying documents that would maybe support the self-serving statements made by your client?
Well, we make the argument, you're asking us to prove a negative. So what we did say is that it was not an additional loan. It was additional collateral. It was additional collateral for the original Fortress $5 million loan. And what you have here is the mezzanine lender took a direct second mortgage on the $500,000 as additional collateral. Now that mortgage was refinanced. It was actually refinanced with Flushing Bank. So
why if it's for a $5 million loan, is that second? In other words, you're giving them a security interest in the property in order to secure them against this loan that you otherwise have to them. Why is it limited to $500,000 if it's for a $5 million loan?
Because that was the additional collateral that they were seeking. They already had the mezzanine pledge, the equity pledge, the owner's equity interest in the property. And that was the additional collateral that they sought. And it was, I'm not going to say it was a throw-in. It was a negotiated additional mortgage, but it wasn't an additional debt. And I think that's an important distinction. The lender felt comfortable with what they had. They asked for additional collateral. And the proof is in the pudding. They were refinanced out by Flushing in full. Nobody left behind the $500,000 claim on a refinancing. So the refinancing was paid out at the closing in full. So there's no claim that there is really any additional mortgage debt. This was a $17 million townhouse. It was a high-priced townhouse, and it was all the liens were paid out. So there is the notion that there is some additional loan out there that was never accounted for, and therefore you're insolvent, to me doesn't hold water in the context of the case. But I do believe it's an issue of fact. At worst, that summary judgment shouldn't have been granted. I also think it's very important on this fraudulent conveyance claim for actual fraud that when the parties acted pursuant to court order, directing the release of escrow, directing payments to Mr. Flowers back from the escrow, that there can't be an actual fraud when you act under a court order. Now, Mr. Flowers was a party at the closing, so this wasn't a clandestine transaction. Everybody understood the dynamics. Everybody understood the escrows. He went to the appellate division. He couldn't get a stay, and the monies were paid out to him, and they were paid back to.
So what relief does that position take you to?
What I think the argument is that it's not an actual fraud. Now they raise these issues of actual fraud, but
but if it's not an actual fraud, what is it that you would have liked to see the court do?
I would have liked to see the court dismiss the actual fraud count, recognize that there's a potential issue of fact on the constructive fraud counts, which are undercapitalization or the lack of.
But you don't really ask. But you don't really ask for that relief on this appeal.
No, but I asked for the motion for summary judgment to be reversed, and I'm not. I didn't cross.
Basically, you seem to be asking your prayer for relief on the appeal. What your brief seemed to be looking for is a hearing.
A hearing as to whether or not there was a true.
But what you're saying now, is you should have been seeking summary judgment and dismissal, which is not what your briefs ask for.
No, I believe there's an issue of fact on that. But I did canvass all the debtor and creditor law statutes. I did brief every one of the issues. And I do believe that I can prove.
I have one more question. Sure. So at the end, what your position here is really is that whatever you did pursuant to court authorization, because when you dispersed the escrows, the court said you could, and therefore you cannot be held responsible under these debtor and creditor law sections that you've been charged with.
Particularly the actual fraud count, particularly.
Okay, let's hear from opposing counsel.
Thank you, Your Honors. Good afternoon, Mark Goldie. Please.
I'm sorry I interrupted you while you're introducing yourself. Judge Friedman, I have a question for you. So as I understand the appellant's position, it's that, look, yes, we had this escrow. We had $500,000 in escrow. The court ordered us to have an escrow. But when we dispersed this money, we acted pursuant to judicial authorization. So how could you turn around and say that we've engaged in some sort of fraud? What's your response to that?
Two responses. First and foremost, that money is the tail on the dog. About $3.9 million was transferred at the closing 4 or 5 months before these escrows were released. We haven't spoken.
Where were those funds transferred to?
They were transferred primarily to Milton Rinsler, and I believe also to Dominion, which is also Milton Rinsler.
But there are other transfers made, were they not, to bona fide creditors who had extended mortgages on this?
Certainly, and those are not challenged. And look, after all, Judge Solomon's escrow orders simply resolved the question of who was entitled to the escrows. Was it Flowers or was it 73rd Townhouse? And they authorized the escrow agent to happen to be.
So those earlier transfers that were made, what judicial determination were they violating?
They weren't violating a judicial determination. However, they did render 73rd Townhouse insolvent and were thus fraudulent conveyances given Flowers' claims. And there was so much money.
What was the status of your claims at that point? I mean, after all, Supreme Court at that point only says, well, you're entitled to specific performance.
Correct, and it had dismissed the 73rd Townhouse's counterclaims to undo the contract.
So give me the time overlay between this dispersal of $3 million plus and the Supreme Court having the case and coming eventually saying, but you're entitled to a specific performance.
All right. I believe that on September 29th, this Judge Solomon dismissed the counterclaims by 73rd Townhouse and as 2006. And on October 12th, she ruled that there had to be a closing and granted specific performance, and that some money would go into escrow. And there's a second order that put more money into escrow, which I can't remember.
And the money goes into escrow. And when was the $3 million plus dispersed?
At the same time it went into escrow, which is at the closing, which is November 29th, 2006.
So they're not in violation of a court order at that time.
That is true.
They're doing whatever Supreme Court told them to do.
You're saying that you don't need to be in violation of a court order, though, right? You just need to have a transfer when you're insolvent and it's the insiders, so it's deemed to be without fair consideration. It's not really whether it violated a court order or not. Is that correct? That that's your position?
Yes, absolutely. It's straight reading of the debtor and creditor law.
And were there badges of fraud shown with respect to those transfers, the 3 million plus transfers?
Absolutely. The badges of fraud.
Badges of fraud there.
Sure. Oh, Judge Bannon does reference them, and they include that we're talking about a closely held family LLC where the person who wrote the check was really writing it to himself or to his family members. There were no, corporate controls, no minutes, no individual existence of these different LLCs. And this is all in the briefs. I mean,
Does any of that matter? Does any of that matter if they don't owe you money?
Well, it matters. Those things matter for purposes of proving intentional fraudulent conveyance. They don't matter.
That matters only later on when the appellate division restores your claim for an abatement. At the time that they did it, they didn't owe you any money, did they? Supreme Court says the only thing they needed to do is to put money in escrow, and they do that.
That's true, but that oversimplifies what happened. I mean, what happened was that 73rd Townhouse was seeking to rewind a transaction. And if it had won, and this is what the prior appeal that resolved those two escrows, if it had won, it would have had to turn $17 million and change back to Mr. Flowers in exchange for the keys. So at that time, whatever time this was, any time between October 2006 and I guess the decision in 2008, both parties were asking to have the same body of money returned to them. This was a live dispute at all times, and that the abatement claim existed at all times.
But live dispute, but at the time that the $3 million plus is dispersed, there's nothing which says that they owe you any money.
I suppose that is correct.
Well, that meaning that no judicial determination, but there's still a claim, right?
Absolutely.
A claim
and do you need a judicial determination, or is it sufficient that there is a claim for those monies?
A claim alone is sufficient. I mean, normally there isn't a judicial determination.
But it's a claim which is defeated at Supreme Court.
But it's still an active litigation, right?
Still a claim. And the appellate division hasn't spoken on it, correct?
Yes, and yes.
Thank you.
They had spoken on it to the extent of denying you a stay. Is it yes to that too?
Yes, that is correct. I'd also like to point out, though, that the escrow orders don't say anything about what 73rd Townhouse was permitted to do with the money. I mean, if they had taken the money and done something illegal with it, no one would say, oh, well, there was an escrow order. We could do as we pleased. All the escrow order resolved was who received the escrow. And it didn't actually resolve any of the parties' claims. Maybe that's an oversight.
Make the argument that even setting aside the escrow funds, it'd be a finding of insolvency. Isn't that what your expert opines?
Yes, absolutely. And that opinion is really untested.
Wrong about distributing those escrow funds. There's still an argument you're making that there would be an insolvency.
Absolutely.
Okay.
And can I speak briefly just about the remedy? Because what Judge Bannon did was she grafted some of the factual statements in a case called Farm Stores. It's on the last page of her decision as an affirmative obligation of Mr. Flowers. He wants Flowers to prove that each of the defendants was aware they were receiving money from 73rd Townhouse and had in fact consented to receiving money while the judgment remained unpaid.
And you're making an argument that you should not have to show intent because it's imputed to all of them.
Yes, and specifically that under Section 278 of the DCL, there is no fair consideration received, and therefore I do not need to prove what any individual knew. And I mean, I would just point the court toward one decision from the New York Court of Appeals. It's CFTC v. Walsh, 17 New York 3rd, 162, which runs through the requirements of Section 278 of the DCL and 272. Fair consideration involves a transfer for fair equivalence in good faith or an antecedent debt. And of course, there's no good faith here as a matter of law and no fair consideration as a matter of law because they're all insiders. There was no antecedent debt because the debt is the debt to the banks, which was paid. Right. So
let's hear from Appellant now. Thank you.
Yes, I think it's important that we don't lose sight of this fact. The townhouse cost $17 million approximately to build. It was financed for approximately $11.5 million. The judge below made note of the fact that it was the financing and construction was funded by bank loans and Mr. Rinsler's personal loans. So at the closing, those personal loans were legitimate loans that went to build and fund the construction and enable the townhouse to be delivered to Mr. Flowers. Those loans were repaid at closing or at about closing. Mr. Flowers was party to that. The escrows were created at closing. There was no issues that the prior loan repayments to Mr. Rinsler had any earmarks of being improper. The two escrows were created. They were recreated at closing, They were properly dispersed pursuant to the order. And what we're really looking at is what happened post-closing in terms of at the date of closing, there was no claim in place. When they say it was just a claim, no, it was a denied claim. Justice Solomon denied a price abatement.
Okay, thank you. Thank you very much. We've heard all the arguments. This concludes oral argument for today, and the court is now adjourned.
Thank you, Your Honors.
Thank you.